Hi and welcome to IP series COVID-19 edition, where we talk about everything IP related from creative and innovative aspect. Like I've always said, IP is everywhere. IP basically means intellectual property. So we're talking copyright, trademark, patent, industrial design, trade secret, right of publicity, geographical indications, etc. This IP series is produced and edited by me, Rita Amori Chinda. You can also follow me on Anchor. You can follow me on Twitter at Esmeraldo99, where I usually do like the IP series tweets. So, in the last episode, I said we had 4 Nigerian cases we're dealing with, and we already talked about the first 2, which were the First Bank and Extreme Creativity Expression Limited case, where I titled it The Battle of the Logo, and then we talked about right of broadcasting rights in relation to the case against Airtel and NUC, where a 10 years dispute ended with Christian Ogodo getting a judgment for 703 million naira as damages for copyright infringement. So today's we'll be dealing on copyright, basically. One from the entertainment sector, the famous case of the Cynthia Morgan issues with her record label and manager, and the second case is about photography. But before I go into our case study for today, I have an IP news. So I did see a post recently about Kanye West applying for a trademark for the word Yeezy. We already know he has a shoe collection called the Yeezy. So now he's registering Yeezy as a word mark to be used for anything that's cosmetic related, facial marks, concealers, hair products, etc. Like a whole bunch of lists. If you've come across the post, Kanye is a musician, and Yeezy is like a stage name or album cover, whatever. But this is another way for artists to actually exploit their intellectual property through merchandising. So Kanye West now is using Yeezy to create products, delve into product creation, exploiting and making money from the word Yeezy. So at the moment now, when the trademark application is finally approved, you can't have a product called Yeezy shampoo or Yeezy concealer or Yeezy facial marks or Yeezy eyeshadow, whatever. You can't do, as it's now exclusive to just Kanye West to use, and the same way his heirs, his children and generation will use it if they go into brand expansion. And delving into the cosmetic line is another way of brand strategy and expansion. So he already has a shoe collection called the Yeezy collection, and now he's going into the cosmetic market. So let's get right into our case study. The first one we'll be talking about today is titled, it's all about image rights, right to publicity, and copyright infringement. So if you've been following my series, I'm sure you've heard me talk several times about copyright infringement being a violation to an IP owner, where someone uses your work without your permission or authorization. That's classified as an infringement, because every IP owner has exclusive right to do whatever he wants with his work. So in today's case study, it's between Mrs. Amuda against Alhaji Atiku Abubakar and his campaign director Dr. Bukola Saraki for the unauthorized use of the photograph of a Lagos-based trader. So Mrs. Amudu Adeleke is a Lagos-based trader, and her picture, or a picture was taken, and she was in that photo, and it was put on their campaign billboard. So the plaintiff, which is Mrs. Amudu, went to court, suing them for the unauthorized use of her photograph on their campaign billboard, which was published without her consent. That it caused her a lot of embarrassment. When she took the matter to court, she had filed and asked the court to grant her 45 million naira, but at the end of the day she ended up getting 5 million, which the court said would be paid by the defendant. So questions that arose for me: can I sue someone for taking a picture of me and then publishing it without my consent? Like I've always stated, copyright is an IP that grants the author or creator automatic protection from the moment the work is in a fixed medium, and then some sort of skills and effort have been put into that particular work. We already know that the copyrights, like I already said, vests initial exclusive right to the author. The author also has the right to reproduce the work in any material form, publish the work, or make an adaptation of the work. But in this particular case, it wasn't Mrs. Amudu that took the picture. It was someone else who took the picture of her. So what are the issues? Why did she go to court to sue Alhaji Atiku Abubakar and his campaign manager? Now you have, when I started, I talked about image right. I also talked about right to privacy, and then infringement. So under the Nigerian Constitution, particularly Section 37, you as a citizen, you're entitled to your right to privacy. So if someone comes and takes a picture of you and decides to put it up on an illegal site or in a porn magazine, you can sue them because your rights your privacy were infringed. You were not even consulted or told what they were going to use the picture for. Then you also have issues on image rights, right of publicity. So you who was featured in that picture, now you have the right to control how the picture should be used, and any other aspect of your identity that may be used or exploited for commercial purposes or whatever purpose. It's not her photo, but it is a photo of her, as the face belongs to her. So she definitely does have some sort of right to sue for rights of publicity, image rights, and right to privacy. Then the copyright aspect will come to like I said, every copyright owner has exclusive right to reproduce a work, distribute to the public, communicate it to the public, license it, sell it, or give it out to anyone they wish to do, to maybe to make money from it. So these are the issues that sort of arose from that particular case. I don't know how many persons have been able to come across the case, but this is one case that actually crossed my timeline at some point, and I said I was going to talk about it. So if let's say you go to a wedding, you're a guest at a wedding, and they take a photo of you and decide to publish it, use it for advert, say any advert, and they don't tell you, you can always sue them for infringing your privacy, not giving you control over how the photo of you, since it's your face, because when someone sees, they might associate you with the person or the brand or whatever. So that's that for copywriting photographs. Then you have the Cynthia Morgan case, which is the last Nigerian case I'm treating for this week. Not for this week basically, but based on the episode. So we'll go into another episode talking about another Nigerian case as well, or cases rather, very interesting one. So you also have the fourth case out of our episode 3, the Cynthia Morgan against Jude Okoye and her former manager Joy Ntongo. So there are a lot of controversies that arose after Cynthia Morgan did an Instagram live and raised some issues, and certain things caught my attention. So so we found out that creatives generally try to not engage lawyers, especially entertainment lawyers or intellectual property lawyers, from the moment they start to kind of build their profiles and portfolios and stuff. Also, when it comes to agreement, they don't see the need why they should get a lawyer to vet or even draft a proper agreement for them with the right clauses. Now, it would seem that for Cynthia Morgan's case, it was just a document downloaded off the internet, and then she gave it to Jude Okoye to sign. So why do you need a lawyer? You need a lawyer to properly advise. You need a lawyer who's grounded in entertainment or the business side of law or intellectual property, basically, to give you proper advice. What are the rights of a copyright owner? I've already listed in the previous conversation when I said you have the right to license your work, you have the right to distribute your work, communicate it to the public, to reproduce it. So what are the rights of a record label? So basically, the record label has the responsibility to actually help you in building your portfolio as an artist. They're practically investing in you, so they would want to see a return of investment in what they've put their money in, and that is where the artist needs to work extremely hard and also keep to the terms and conditions of his agreement. Now, one other issues that I saw when I was reading the contract, because the contract was finally posted by Cynthia's manager on the internet, and I saw where they made mention of an exclusive license. Basically, when it comes to licensing, you have two forms of licensing. So you have the exclusive license, which means that this license between party A and party B and no other third party. But if you're going to go outside of that, that's going to be like a sub license, and you will need the authorization of the licensor. The licensor is the person who owns the work that you wish to license from, so it's called a licensor. So you need the authorization or permission of the person to sub license to another person. Why a non-exclusive license means you're not giving the license to one person, you're giving it to more than one person, basically. So Cynthia, basically, she did not understand the terms of her contract when she signed it, and kind of felt like her name didn't belong to her, because I think that was the main issue, where she was saying the record label now owns her name, she doesn't have a right to use her name. Meanwhile, the contract said otherwise. Why do you need a dispute resolution clause as in every agreement? So basically, as human beings, we're definitely going to have disputes, or issues will definitely arise, and we'll want to find a way to settle either by talking it out or negotiating, or exploring any mode or mechanism for resolving that dispute. So if it's like a major dispute, parties may want to go to court, but if it's for commercial disputes, parties may want to opt out of court and look for a mechanism that still makes the party retain the relationship they have. So they might opt to arbitrate the dispute depending on what the dispute is about, especially when it's a commercial dispute. They might opt to also mediate, they might opt to conciliate or negotiate. So yeah, the ungoverning law. So it's the law that the parties agree to, that when a dispute arises, that's the law that will bind their disagreement. That's what the governing law clauses mean. The IP ownership. So he said in the entertainment space, the record label owns the master's recording. Last year we saw the case of Taylor Swift, where she came out saying how all her masters were owned by her former record label, and issues. People were for and against, saying record labels should not own the mastered records of an artist. I think, again, if an artist has like a good bargaining power, you can always negotiate that to be a co-author to your masters. But IP ownership basically means intellectual property ownership, so it has to be stated. If it's not stated in the agreement, at least it should be agreed orally, but it's best that it's stated in the contract who owns what IP, whether it's the copyright, the songs itself, the sound recording, the lyrics, or trademark of your name, merchandising, whatever it is. So how can an artist build themselves to have a bargaining power? Start at the table when signing to a record label. So start to develop yourself, create a brand for yourself, build yourself, own certain intangible assets that when you are being signed to a record label, it seems like you're coming with something. You're not just coming empty-handed. You have something to offer. So it's more or less like give and take. Train yourself, develop yourself, understand how your industry or your sector works, understand the business of music, know the important things, the relevance of a contract, what intellectual property means, why it's very important for you to stick to the terms and conditions of your contract. Like I mentioned earlier, brand yourself, especially now where you have thanks to the digital age, you have the likes of YouTube, SoundCloud, etc. You can make use of that, build your own fan base, and a scout might just see you and then sign you up to a record label. How do you exploit your work? So you exploit your work by commercializing what you own. So from your name, which can be registered as a trademark, you can also use your name to create a merchandise, just like what I said Kanye West is currently doing. He has a shoe line and now he wants to register use Yeezy as a word mark for his cosmetic line. You can license it, do sync licensing to be used in movies, advert, etc. That generates funds for you. You get paid royalties for a fixed period of time, and then your heirs can also benefit from that. When it comes to copyright, basically copyright protection lasts for the duration of the lifetime of the copyright owner, and then 70 years after he's dead, his family can also benefit from that. We've seen the family of Marvin Gaye, Whitney Houston, Michael Jackson, Prince, Fela, who's a Nigerian. I think that's about it for our IP series episode 3B. Thank you so much for listening. If you have questions, do send me a message or send me an email to ipseriesInfo@gmail.com or Pardoo PARDOO Prime Legal @gmail.com, or you can follow me on Twitter and ask me questions. My Twitter handle once again is Esmeraldo99, or just Google Anwari and I'll pop up on your screen. For those who have been listening to my other podcast series, I say thank you so much. Until next time, my name remains Rita Anwari Chinda. Thank you for joining us. Bye.